4. Creating a quasi-private cause of action for revocation of corporate charters. A. Necessity of an action-forcing mechanism. Current economic and political realities as perceived by the states make it unlikely that any state attorney general will initiate a quo warranto proceeding to revoke the corporate charter of a large corporation such as Union Carbide. Although the law is fairly clear on the interpretation of misuse and abuse of charter powers within the revocation context, it is unlikely that a state attorney general will take steps to initiate a charter revocation action unless citizen groups encourage such an action. It is equally clear that if evidence is gathered by a citizen group that a large corporation is a major source of environmental degradation, the Attorney General should act. The long list of violations occurring over several decades by large and small corporations alike validates the argument that regulatory enforcement fails in the face of a corporate scheme of wrongdoing. Many times state officials ignore the corporate violations or the corporation ignores the enforcement actions. Even when an assessment of civil or criminal penalties is levied, the corporation many times remains undeterred in its illegal behavior, as a result of the corporation's ability to externalize the costs of compliance by passing the additional cost on to consumers. In the face of an unwilling Attorney General, it is left to the public to attempt to curb these systematic corporate abuses. However, the initiation of a revocation action by a private individual as a collateral action to remedy these corporate injuries has been strongly discouraged by the courts, who cite Section 1101 for exclusive enforcement by the Attorney General. New York courts have declared that the question of corporate existence can be raised only by the sovereign power to which the corporation owes its life, in some proceeding for that purpose by or in behalf of the sovereignty itself. Citizens faced with corporations which have consistently abused their charters by violating state law have a variety of means by which to seek monetary or injunctive relief against the corporation, including shareholder suits, civil proceedings for damages or equitable remedies, and statutory citizen suits. However, seeking a judicial remedy each time the corporation violates an environmental statute is not as effective as the alternative of charter revocation. By forcing citizens to seek piecemeal remedies for individual injuries, citizen groups are left without a remedy when faced with intransigent corporations which continue to violate environmental statutes, even after state and private enforcement actions have occurred. Citizen lawsuits then become an inadequate remedy with which to battle a corporate scheme of wrongdoing as well as burdening the courts and taxing the limited resources of the citizen groups. In addition, corporations that have an international resource base can bankrupt citizen groups whose financial resources are limited. These suits may become protracted legal battles which solve nothing, as the environmental and health harms worsen. Too often, the citizen groups are unprepared and underfunded for such a daunting challenge. To make the situation worse, many corporations continue to violate state environmental laws even after the assessment of liability. They simply view the expense as a cost of doing business, and thus the deterrent value sought by the imposition of liability is lost. Faced with a complacent Attorney General unwilling to bring these revocation suits, citizen activists must seek an alternative remedy by forcing the Attorney General to institute a charter revocation action against the corporate violator. This path, while promising direct citizen access to charter revocation, is strewn with legal landmines. Such a proceeding would be in the nature of a writ of mandamus to compel, by which the plaintiffs would attempt to force the Attorney General to institute the legal action mandated by law. This proceeding must be brought under the framework established by Article 78 of New York's Civil Practice Act. Other assorted problems may face individual litigants or organizations, such as standing and whether or not the administrative remedies have been exhausted. These, however, are not covered in this section, which concentrates on the judicial review of the Attorney General's failure to enforce the charter revocation statute and the hurdles that will be encountered along that road. The first hurdle to such citizen-initiated actions would be overcoming the presumption established by New York case law that decisions made under the purview of prosecutorial discretion are not subject to judicial review. The second hurdle would be to alter the standard by which the judiciary would review the Attorney General's refusal to initiate the revocation process. New York case law sets forth a substantial evidence test which may be applied to the administrative decision of the Attorney General not to revoke the corporate charter. Under this test, the court would simply review the record to determine whether the decision not to initiate revocation proceedings is supported by a substantial body of evidence. Although the hurdles to a quasi-private cause of action are substantial, such a mechanism under limited circumstances would further the public interest and grant those most affected by corporate environmental violations a permanent remedy through the courts. The New York courts have recognized a category of administrative decisions which have been designated judicially unreviewable under the heading of prosecutorial discretion. The reasoning behind the creation and maintenance of this general threshold exemption from judicial review is based on two concerns: the separation of powers doctrine and public policy considerations that militate against judicial review of prosecutorial decisions. In Hassan V. Magistrates Court of New York, a New York trial court, stated the separation of powers concern in ruling that each function of government is separate and distinct. Each branch of government is burdened with its own responsibility, and the judicial branch under ordinary circumstances should not sit in judgment on the discretion lodged in the others. In commenting on the role of prosecutorial discretion, a New York Supreme Court stated that the discretion is, in its nature, a judicial act, from which there is no appeal, and over which courts have no control. Public policy considerations, however, seem to dominate the judicial conversation, outweighing separation of powers concerns. In People v. Bunge Corporation, a trial court held that whatever action taken by the Attorney General under a discretionary authorizing statute was not subject to judicial review. In Bunge, the New York Attorney General served, but did not file, charges against the defendant corporation for engaging in fraudulent business practices which included bribery and forgery. Defendant agreed to a consent judgment. The banks that had been swindled by the defendant corporation then brought an action in mandamus to force the Attorney General to reopen the suit. In concluding not to override the discretion of the prosecutor, the court stated that would be a vexatious practice for a court to substitute its judgment for that of the Attorney General by intervening to review the conduct of his high office or by dictating the manner in which he shall proceed to discharge the solemn responsibilities imposed upon him. Later in the opinion, the court reasoned that mandamus action was unnecessary because other remedies were available to force the Attorney General to become more responsive to the protection of the public interest, including his removal from office, or the election of a successor worthy of the high position. The Court of Appeals upheld the judgment and commented on these policy considerations, stating that the Attorney General must be given the personal discretion to decide upon the remedies which he wishes to employ. To allow intervention by private individuals to further their own private aims might seriously jeopardize the purpose of the Attorney General's suit. Although the presumption of non-reviewability will be difficult to overcome, exceptions to the presumption are supported by compelling policy reasons that have been advanced by several commentators. The possibility of the abuse of prosecutorial discretion in bringing suit and in failure to bring suits has convinced one commentator, Ruth Kolker, that narrow exceptions should be allowed to the general presumption of judicial non-reviewability. Kolker has argued that, in light of political considerations and biases which have become evident in the administrative decision-making process concerning whether or not to prosecute, judicial review is needed more when prosecutors decide not to prosecute than when they do decide to prosecute. Additionally, due to limited prosecutorial resources, prosecutors must use discretion in choosing which cases to prosecute. However, they should be deemed to be acting in bad faith when they make decisions inconsistent with their statutory mandate. In such a situation, judicial review may be appropriate. Another commentator, Cass Sunstein, proposes that the increase in federal mandamus litigation brought to force federal enforcement of certain statutes is part of a movement which has abandoned the traditional focus on private autonomy in favor of an effort to ensure the identification and implementation of the values set out in the governing statute. In reviewing the Heckler v. Cheney decision, Sunstein outlines the problems inherent in granting judicial review of enforcement decisions, citing the lack of a formal record of decision to review, delays in agency decision-making, resource allocation concerns, and the cost of formalizing informal decisions. However, the presumption against review is not reinforced or justified by administrative concerns. The increasing politicization of the administrative process and the reasoning behind the increase in mandamus litigation support the creation of an exception to the general presumption of non-reviewability of prosecutorial discretion. The case history of the Charter Revocation Statute bears out the hypotheses of Kolker and Sunstein. The virtual disappearance of charter revocation actions by the 1920s conveniently coincides with the rise of corporate America as a primary employer of citizens and the consolidation of industrial capital through the emergence of quasi-monopolies. The impact that massive accumulations of wealth have on the political system is well documented. It follows that a statute directed at corporate death would be shelved in favor of large economic interests. Sunstein's analysis is mirrored by the history of the Charter Revocation Statute in New York. A revival of the corporate charter revocation action provides a viable tool to control the private autonomy of corporations, leading to the brink of ecological disaster. Sunstein's concern about ensuring the implementation of the values set out in the governing statute also is satisfied by this revival, since the legislatively mandated standards for revocation would be enforced by these actions. The policy reasons of Kolker and Sunstein bolster the argument in favor of the exception to judicial non-reviewability. Allowing judicial review would ensure that prosecutorial discretion is exercised in the absence of political pressures, providing a check on the vast discretionary power of the prosecutor. Such a check also would ensure that the legislature's grant of the Attorney General's discretion is not circumvented in favor of corporate-private autonomy. 1. Revocation strategy, under the equitable exception or a two-step statute exception. In finding an action-forcing mechanism that would force the Attorney General to initiate a charter revocation action, citizen litigants are faced with a choice of two possible strategies. First, they can argue that New York courts have created an equitable exception to the general rule of non-reviewability of prosecutorial discretion. Although New York courts have been reluctant to grant mandamus to compel prosecutorial action, they have occasionally ordered mandamus where the equitable concerns justify judicial intervention. This judicial approach can be categorized as an equitable exception to the general presumption of judicial non-reviewability. A second strategy for obtaining judicial review of an official's discretionary action is to argue that the courts have already carved out a narrow exception to non-reviewability for certain types of statutes. These cases involve two-step license revocation statutes that force the prosecutor to find a threshold violation prior to the initiation of license revocation proceedings. A. Action forcing under the equitable exception to the general presumption against judicial review of prosecutorial discretion. A citizen litigant seeking to force the Attorney General to bring a revocation action can argue that the New York courts have shown a willingness to override prosecutorial discretion by defining a category of equitable exceptions to the general presumption of judicial non-reviewability. In Seminara, the New York courts opened the door for judicial review of decisions that have been traditionally considered prosecutorial discretion matters by holding that a complaint seeking mandamus to compel prosecution was not insufficient as a matter of law. In Seminara, individuals sought to compel township officials to enforce an ordinance relating to sandbank and pit, topsoil removal and other excavations. The plaintiffs alleged damages resulting from this lack of enforcement, including the loss of township license revenues from those engaging in the activities covered by the ordinance. The trial court agreed with the plaintiffs, and held that the complaint was sufficient as a matter of law. The court stated that they can require, but cannot control, the exercise of judgment or discretion by the town officials. On appeal, the court was again petitioned by the defendants to dismiss the complaint as insufficient as a matter of law. In reaching its conclusion that the complaint was sufficient, the court reasoned that the plaintiffs fulfilled the legal requirements by including statements of the validity of the ordinance, the alleged duty of the town officials to enforce the ordinance, and specific instances of their refusal, neglect and failure to enforce the ordinance. In the dissenting opinion, Judge Fuld agreed with the defendants that the decision to enforce the ordinance was a purely discretionary one. He declared that to mandate officials to enforce the town ordinance would truly open up a Pandora's box of controversy and litigation. The holding in Seminara was narrowly construed by the Appellate Division of the New York Supreme Court in Fried v. Fox. In Fried, homeowners filed suit to compel various officials of the city of Yonkers to enforce the zoning laws against certain property owners. In Seminara, the Court of Appeals sustained an Article 78 petition where illegal acts resulted in the waste of public funds. In contrast, the Fried Court did not find any waste of public funds or that the property owners committed any illegal acts which were so flagrant and numerous as to be injurious to the public welfare, and therefore, the complaint was dismissed. Both the Seminara and Fried courts have intimated that the general presumption of non-reviewability stated by the court in Hassan V. Magistrates Court of the City of N.Y. does not serve as a blanket prohibition of judicial review. The Fried Court's characterization that reviewability is contingent upon the waste of public funds or the magnitude of the public injury raises interesting implications concerning litigation to force the Attorney General to bring a charter revocation action for environmental violations which are hazards to human health and the environment. A complaint which combines these court-delineated factors with an allegation of the Attorney General's failure to bring an action in accord with Section 1101 has a chance of success under the Seminara and Fried analysis. On the other hand, more recently, New York courts have been less lenient in granting this override of prosecutorial discretion in equitable cases, and have returned to the general rule of a presumption of judicial non-reviewability of prosecutorial discretion. In the 1971 case of Posner v. Levitt, the court held that mandamus was inappropriate to compel a county comptroller to institute litigation to test the legality of the state budget. In Levitt, the court declared that the duty was not a ministerial one, and that the advisability of undertaking such litigation involves broad areas of judgment and discretion. Therefore, the court reasoned, the comptroller was under no statutory or constitutional duty to bring the action. Despite the court's refusal to review the comptroller's decision in the Levitt case, The situation there can be distinguished from an action to revoke a corporate charter. First, levitt involved the refusal of the comptroller to bring a declaratory judgment action challenging the legality of the state budget. Questioning the legality of a state law involves broad areas of judgment and discretion. An attorney general considering a revocation action, however, must first make a factual determination as to the threshold finding of a violation before bringing the action. In this manner, the legal processes in each situation are distinguishable. Should the citizen litigant, applying the equitable strategy found in Fried and Seminara, fail in her action for the reasons elucidated in Levitt, she may wish to attempt another approach which places the decision not to enforce the charter revocation statute under judicial scrutiny. B. Action forcing under the two-step statute exception to the general presumption against judicial review of prosecutorial discretion. An alternative to a purely equitable exception to non-reviewability of Attorney General non-action would be to argue that courts have granted review in cases involving two-step license revocation statutes. This approach avoids public policy and separation of powers concerns inherent in the equitable exception. The theory is that Section 1101 embodies legislative standards for the exercise of the charter revocation powers by the Attorney General. In essence, this approach will force a showing that once the mandated standards in Section 1101 are breached, the Attorney General is legally obligated to bring an enforcement action to revoke a charter. The Attorney General is statutorily forced to make a threshold finding of a violation of state law before initiating charter revocation proceedings when there is a violation of any provision of law in the transaction of business in a persistently fraudulent or illegal manner. Language in Section 1101a(2) of the New York Revocation Statute. Most license revocation statutes establish this two-step dichotomy. First, a violation must be shown. Second, the initiation of formal proceedings to enable a revocation of the license granted to the violator begins. Under the Charter Revocation Statute, this process holds true, especially in cases brought under the misuse category of revocation where a violation of state law must be shown prior to the initiation of a revocation action. In Friedis v. Guggenheimer, the court held that the failure to revoke a license when statutory violations have occurred is judicially reviewable. In Friedis, the petitioner brought suit against the Department of Consumer Affairs for failing to revoke a newsstand operator's license when he violated regulations governing the operation of newsstands. The department's regulations required the newsstand operators to work at the newsstand for 8 hours per day, and prohibited them from holding other full-time employment. The plaintiff brought suit against the department and sought mandamus to compel the department to revoke the license of an operator who was in violation of both regulations. In reversing the lower court's refusal to issue a mandamus due to the discretionary nature of an enforcement action, the Friedis court declared that discretionary power is not absolute. It is subject to the limitation that it cannot be exercised arbitrarily. In determining whether or not the action was arbitrary, the court looked to a previous revocation action and stated that the commissioner's present position is totally at odds with the action she took against a previous licensee, whose license had been revoked under similar circumstances. Thus, in similar litigation brought under a two-step charter revocation statute, courts could look to prior actions of the Attorney General. The courts may be open to this approach, which would show the courts that Attorney Generals have initiated charter revocation suits in the past, and the particular violations which were successfully litigated. The court in Friedis looked to a similar factual scenario in which a license had been revoked. This illustrates that in charter revocation actions the court may look to similar factual situations in which a charter had been revoked in response to violations of state law. 10 years prior to Friedis, a New York Supreme Court held differently when dealing with an apparently similar two-step license revocation statute in Lewis v. Lefkowitz. In Lewis, the court held that a mandamus would not be granted to force the Attorney General to bring suit against a state-owned port authority. The plaintiff in Lewis, the Freethinkers of America Incorporated, filed suit seeking in order to direct the Attorney General to cancel the leases for the construction and maintenance of religious chapels at Idlewild International Airport in New York City. Plaintiffs brought the action under Chapter 301 of the Laws of 1950, which stated that the Port Authority was immune from any suit other than suits, actions or proceedings brought by the Attorney General of New York, who was thereby authorized to bring such suits, actions or proceedings in his discretion. In reaching its conclusion that a mandamus to compel was not appropriate, the court voiced public policy and separation of powers concerns. The court further declared that if the Attorney General abuses the great power entrusted to him, a remedy may be found in his removal from office, or in the election of a successor worthy of the high position. The court focused on the possible infringement upon sovereign power if the judiciary reviewed such a decision, stating that the clear policy of the states is to have their highest law officers screen access to the courts or injunctions. Only in those particular cases where in their discretion such action would seem warranted. Anything else would be an infringement of the basic principle of sovereign immunity. The result in Lewis is distinguishable from Freitas, and therefore would not impede a litigant's quest for judicial review of an attorney general's decision not to bring a revocation action. Despite the governing statute's facial similarity to Section 1101 and the similarity between Lewis and later suits brought to force the New York Attorney General to revoke a corporate charter, the Lewis case would not qualify for the same two-step license revocation exemption to the general presumption of non-reviewability outlined earlier in this paper. The crucial difference between the two actions lies in the authorizing statutes. The statute at issue in Lewis conspicuously lacks the legislative standards delineated in Section 1101 to guide the discretion of the Attorney General. Not only does the Lewis statute lack these guidelines, its internal structure is also dissimilar to that of Section 1101. The Lewis statute simply gives the Attorney General discretion to bring a suit whenever he decides that it is necessary to do so. In this respect, the statute is similar to Section 701A(2) of the Federal Administrative Procedure Act, which declares that an action committed to agency discretion is exempt from judicial review. Unlike the language found in Section 1101, no threshold finding of a prior violation must be shown in order to proceed with the revocation of the leases granted by the authority. This stands in stark relief to the legislative standards established by Section 1101 that demand a threshold finding of a violation of any law or persistently illegal or fraudulent conduct prior to the initiation of revocation proceedings. Thus, the Lewis Court, having determined that the statute does not guide the discretion of the Attorney General, relied on public policy concerns to support its judgment that the decisions of the Attorney General are exempt from judicial scrutiny. Therefore, under Freitas, which represents analysis of a true two-step statute, courts should analyze prior agency action to determine whether present agency action is consistent. In addition, in considering whether to compel a public official to undertake an action under the two-step license revocation statutes, New York courts have assigned a large role to equitable considerations. In ruling on an action brought under Article 78 of New York's Civil Practice Act, which challenged a decision made by the New York State Urban Development Corporation, the New York Supreme Court declared that an administrative decision would be overruled where the matter involved is one of great public interest, and granting the relief requested would benefit the general public. In Crane v. Anaconda Company, the New York Court of Appeals declared that in failing to prosecute cases, the exercise of mandamus to compel lies in the discretion of the court in light of equitable principles and will be granted with caution so as to prevent abuse. A narrow exception to the general presumption of non-reviewability for two-step license revocation statutes would avoid the policy dilemmas raised by granting mandamus to compel prosecution for violations of ordinary statutes. First, the number of cases that would qualify for this special judicial treatment would be small, therefore countering the fear of a floodgate of litigation. Secondly, in response to Kolker's concerns, a judicial check would be exercised over any political factors that would exert influence over the decision to initiate a corporate charter revocation action. Finally, recognition of the special nature of the two-step license revocation statutes would guarantee that the basic values of the statute would be carried out by the Attorney General. Section 1101 embodies these specific legislative values in mandating the grounds for charter revocation. The general presumption of non-reviewability which is presently used effectively whitewashes the legitimate legislative intent to establish standards for revocation of corporate charters. For courts ruling on the reviewability of the Attorney General's failure to prosecute under charter revocation statutes, equitable considerations may tilt the balance towards granting judicial review of the Attorney General's decision not to initiate revocation proceedings, especially where serious environmental violations are at issue. Under Section 1101's persistently fraudulent or illegal language, equitable considerations will inevitably play a large role, as they did in Anaconda, in achieving redress. The more egregious the environmental violations, the more likely that the courts will respond by granting review and by extending the line of case law that supports favorable judicial treatment of these two-step license revocation statutes. The New York courts have exhibited a willingness to carve out an exception for two-step license revocation statutes to the general presumption of judicial non-reviewability of prosecutorial discretion. The time may be ripe to extend this line of case law in the face of the continued environmental violations of many major corporations. By coupling the exemption of two-step license revocation statutes from the general presumption of non-reviewability with the excellent equitable grounds offered by such a proceeding, this type of suit has a good chance of success. 2. Standard of review for action forcing corporate charter revocation actions. If the litigant succeeds under the quasi-private cause of action theory by convincing the court that the Attorney General's decision not to prosecute is judicially reviewable, it then needs to be determined what standard of judicial review should be used to evaluate the Attorney General's decision not to initiate charter revocation proceedings. Under New York's Article 78, an arbitrary and capricious standard is to be applied whenever an agency is not required to conduct a trial-type hearing in making a determination. On the other hand, a substantial evidence test is applied under Section 7803(4) whenever an administrative determination is made through a formal hearing process. Even if the Attorney General's decision were subject to the more stringent substantial evidence standard, which is generally viewed as being less deferential to the agency decision-maker, the New York courts apply a rationality or consistency test, which essentially is based on settled law principles. As one New York court has noted, rationality is what is reviewed under both the substantial evidence rule and the arbitrary and capricious standard. The court emphasized a settled law approach in determining whether an administrative decision was supported by substantial evidence in Casey v. Hartnett. In Casey, the New York Commissioner of Labor appealed a determination by the Unemployment Insurance Appeal Board that the claimant was an independent contractor and, therefore, ineligible for unemployment insurance benefits. The court, in reviewing the denial of benefits by the agency, declared that the board's resolution of this question must be upheld if supported by substantial evidence. The court also declared that if a decision is based on essentially the same facts as a prior agency determination that came to a contrary conclusion, the agency must offer an explanation. Its failure to do so renders its later decision arbitrary and capricious. In applying this standard, the court looked to Field Delivery Services, which had similar facts, and in which the board had come to an opposite conclusion as they had in the instant case. In dismissing the defendant's argument that only minor factual differences existed between the two cases, the court stated that the existence of sufficient similar facts requires an explanation by the board of why it reached a different result in this case. The court in Casey specifically stated that it is applying a substantial evidence standard of review, and then in fact it actually applied a consistency standard. The standard adopted by the courts for review of administrative actions and non-actions has been interpreted by many New York courts as a consistency test, in which the courts have compared past agency actions with the challenged ones before the court. In Schwartz Landis Associates v. New York City Conciliation and Appeals Board, a Supreme Court held that the courts will override agency decisions when they are inconsistent with settled law. In Schwartz Landis, the court reviewed the New York Conciliation and Appeals Board's decision to deny a license to a landlord who was seeking permission to refuse renewal leases to residents of a nonprofit psychiatric rehabilitation center. In granting the petitioner's request for reversal, the court stated that while it is quite true that an administrative agency is accorded wide latitude and broad discretion in the contemplation of matters before it, a court will be compelled to interfere if the opinion is not consistent with settled law. The court looked to recent New York case law and determined that the prior decision was inconsistent with settled law. Therefore, the court reversed the decision of the Conciliation and Appeals Board. In reviewing an agency's interpretation of the statute that it is responsible for administering, New York courts have applied a rationality or consistency standard for judicial review. In Charles H. Greenthal Company v. State Division of Housing Community Renewal, a Supreme Court reviewed an agency's formula for determining stabilized rent amounts. The Supreme Court upheld the agency's interpretation, declaring that it is settled law that an agency's interpretation and construction of its own regulations and the legislation under which it functions will be given special deference by the courts if that construction is not irrational or unreasonable. In applying this standard of review to the facts, the court stated that the procedure was not out of harmony nor inconsistent with the plain meaning of the statutory language. The court did not emphasize application of a substantial evidence test or an arbitrary and capricious standard. Rather, the court applied the facts of the case to the controlling settled law to determine whether the agency's actions were consistent with the settled law. The court upheld the agency's action because it was not inconsistent or irrational according to settled law. Both the willingness of the New York courts to review the prosecutor's discretionary decision under two-step license revocation statutes and the favorable consistency standard of review by the New York courts could support mandamus litigation brought to compel the state attorney general to revoke a corporation's charter. The settled law consistency test employed by the court in Casey and in Schwartz Landis, in which the court reviewed the agency's decision based on their prior adjudications of cases with similar factual scenarios, favors a suit brought to revoke a charter. The settled law of corporate charter revocation actions is extensive, And the standard for such revocation action has been clearly enunciated by the New York judiciary during the second half of the 19th century and the early 20th century. The willingness of the New York courts to analyze cases on the basis of the settled law in the area would allow citizen litigants to argue that the Attorney General's decision not to initiate a suit to revoke a charter is inconsistent with the case law developed under the New York revocation statutes. This interpretation adds teeth to the consistency standard of judicial review by directing the reviewing court in a charter revocation case to a favorable body of case law which contradicts the Attorney General's decision not to initiate proceedings directed at revoking a corporate charter.